Welcome to the Melinda Eitzen Show. I'm Melinda. Today we are fortunate to have with us attorney Holly Draper. Welcome, Holly.
Thank you for having me.
I'm so glad you could be here. I know you are a podcaster also.
I am. I host the Texas Family Law Insiders podcast, which targets attorneys instead of generally the end user.
So a little more technical, maybe.
A little more high-level legal discussion.
Right on. Well, we're very glad to have you here. And I know in your practice you do both trial work and appellate work.
Yes.
That's unusual because most trial lawyers aren't also appellate lawyers, right? And I think you've had great success in your appellate career. So how do appeals work for the public? If I don't like what happened at the trial court, can I just appeal and get a do-over?
So an appeal isn't a do-over. Something that's really important to remember with an appeal is you're limited to whatever happened during the trial and whatever's in the record. So if you didn't get to put on your evidence about whatever, the Court of Appeals is not going to hear that. They are only going to get to see what the trial court got to see and hear. So the odds of winning on an appeal are very, very low. So you never, ever want to go into this assuming, well, then I'm just going to appeal if I lose. You really want to win at the trial court level or get a result you can live with at the trial court level because appeals are so difficult to win. And usually they're just because you think that the decision was wrong doesn't mean that you have an appealable case.
We have to show the judge did something wrong in order to appeal successfully.
Right. Usually you're showing the judge abused their discretion or that, the overwhelming weight of the evidence was so against what the ruling was or the judge didn't follow the law, not just that they made a decision that you didn't like, because they have a lot of discretion to make decisions that you don't like.
That's the problem in family law, that there's a lot of discretion. People could disagree, and it's very fact intensive.
Right. And very he said, she said, and who does the judge believe more than the other? And the judge is the one who gets to decide the credibility of the witnesses. So just because the judge didn't believe you doesn't mean that the judge was wrong.
Yeah, so that's hard for people.
Yes.
I bet it helps you as a trial lawyer that you do appeals because you're thinking about what do I need to do not only to win at the trial level, but to set it up for the best possible look back on appeal.
Definitely, because again, it's all about what's in the record. And if you do not get it on the record, or you don't object when you should object, or you don't make an offer of proof, it's not on the record correctly or at all, and the Court of Appeals can't do anything about it. So you're sunk.
Sometimes if I know this is a case that might go up on appeal, maybe based on the circumstances of the case or the wealth of both parties, that it's the type of case where everybody's going to go to the mattresses, so to speak, I might hire appellate counsel to sit with me at trial. Has that ever happened with you, and how does that work? What's the point of doing that?
A lot of people definitely do that. Obviously, you need a client who can afford to do that, and that's part of the problem why you don't see it more. A lot of times attorneys will consult with me. I won't actually go to the trial, but I'll give them a lot of feedback on make sure you're getting this in the record, make sure you are doing this or that, make sure you're objecting to this evidence that you don't think should be in. And a lot of judges, they want to try and run their courtroom the way they want to try and run their courtroom, and they don't necessarily care about your ability to make a good record, and they really don't want to be overturned on appeal, and that may influence it too. So there's trial lawyers that are in front of this court all the time, and they don't want the judge upset with them, might stop objecting when the judge says,
Move
I get
on.
it. Yes, we're not going to do that anymore. But it's so important if you think there is any chance that you might want to appeal, you can't let that stop you. And you have to keep objecting, ask to make your offer of proof.
So if you were there as appellate counsel at trial, you'd be helping coach the trial lawyer, reminding them, because everything's happening so fast in trial. And like you said, the judge may say, move on, and you're wanting to win at that level, so you don't want to aggravate the court. But your appellate counsel can be like, hey, the judge never ruled on that. You offered a piece of evidence, and the judge never ruled on it. And you could miss that easily because you're on to the next thing. So that's kind of part of what the appellate lawyer's doing.
Right. Or you made an objection and the judge didn't rule on it.
Yes.
Or the judge won't let you do something and you need to make an offer of proof. Otherwise, you can't appeal on that.
And explain a little, briefly what an offer of proof is.
So an offer of proof is if, let's say you have a witness that you want to testify about, is an expert, for example, and the judge has excluded the expert. You think this is inappropriate and that the expert should not have been excluded. You have to put on an offer of proof that essentially is the expert testifying to get on the record what that expert would have said. Because otherwise, maybe it doesn't matter that your expert got excluded because we don't know that what your expert had to say would have changed the course of the trial or the ruling. So you have to prove that the error was not reversible error, or that it was reversible error. And the only way to do that is to get that testimony or that exhibit or whatever the judge is not letting into the record as an offer of proof.
Because when we're at the Court of Appeals, we can't then say, oh, Court of Appeals, this is what that witness would have said.
Exactly.
They have to be able to look at the record and see that. So if you didn't offer the proof, do an offer of proof, too bad.
And if the court doesn't let you, which I have seen judges say, it's not relevant, I'm not letting you do an offer of proof, that is reversible error in and of itself to not let you do an offer of proof.
So then you preserve your record.
Yes.
Excellent. So Court of Appeals is one level, and if you file something in the Court of Appeals, they're going to deal with it in some way.
Right. So you are entitled to an appeal in the Court of Appeals, and if you file it, the other side is supposed to file a response. They don't always necessarily, but and the Court of Appeals is going to give you a ruling one way or another, and it's generally going to be a substantive ruling, either affirming what happened in the lower court or overturning it in some way or every way.
But next level, Supreme Court, they don't have to hear everything that's filed up there.
Right. So the Texas Supreme Court is called a permissive court, and they take cases, they don't care about your individual case. They care about the law with respect to the state. And is this case important to the law in the state of Texas? Did the Court of Appeals give us a really bad appellate opinion that we need to do something about? Things like that. So the percentage of cases that actually get heard by the Texas Supreme Court, I believe, is about 10% of the cases that are filed.
So it's a big deal to have your case selected.
Yes.
And you recently got to argue in front of the Supreme Court.
Yes. So this was my second time to get to argue in the Texas Supreme Court. First time was CJC, which was a parental rights case, parent versus non-parent. This one is Starry versus Etheridge, which relates to the constitutionality of protective orders, and a little bit similar in that it was also a case relating to constitutional parental rights.
Oh, so tell us a little bit about that. What is going on, and what is the Supreme Court now trying to decide?
Right. So a little bit of background. In all the places that you and I practice, if we file for a protective order in a family law context, it's going to be heard by the same judge in the same court. You got a divorce in a protective order, same court. SAPSR in a protective order, same court. Well, in Harris County, which is Houston, if anybody doesn't know that, they have a specialty court just for protective orders. So if you file a protective order and a custody case, the custody case is heard by a particular judge, and the protective order is heard by a different judge.
And that could be a protective order against the other parent, like, hey, I want that person to stay away from me, or it could be a protective order trying to protect the children from a parent.
Right. So in the Starry case, it was a protective order. The father sought the protective order against mom as to originally him and their children, but ultimately he dropped it as to himself, and it was just with respect to their 3 minor children.
Okay.
So these people were divorced. They had a 50-50 by agreement possession schedule, functioning under that for, I think, 1.5 years. And then the mother was accused of abusing one of the children. And in Texas, protective orders typically last less than 2 years. However, you can get a protective order longer than 2 years if it is based on the allegation of a felony. You don't need an indictment. You don't need a conviction. You don't need anything other than the allegation that somebody committed a felony offense involving family violence.
Wow.
So here, dad alleges that it was a felony offense, that mom allegedly abused the kids. And also by statute in Texas, you are supposed to have really fast final hearings on a protective order, 14 to 20 days, depending on how large your county is. In this particular case, it was longer because it was 2020, it was COVID. We all know nothing happened on time.
Things moved a little slower.
But, the Supreme Court is looking at how does this impact everyone? And how it impacts everyone is normally you have to have a hearing in 14 to 20 days. What does that mean? That means if you have criminal charges pending, you don't have a chance to, your criminal lawyer is probably going to say, you can't testify. Mm-hmm. Because in a civil case, which a protective order is, you do not get the benefit of the Fifth Amendment.
Oh.
And it also means you don't have the opportunity to conduct discovery. There are you just have to go in there and try to defend yourself or sit there quietly. If your criminal lawyer says absolutely not, you're not going to defend yourself. So in this particular case, at the end of the trial, relatively short trial, lasts about an hour, and protective order cases are usually pretty short. Mm-hmm. The judge issued a lifetime protective order against the mother as to her children.
Meaning she can't see her kids ever again.
Correct.
The kids can't see their mother ever again.
She can't go within a certain number of feet of the school, or she can't communicate with them in any way unless it's through a court-appointed lawyer.
So she allegedly did something harmful, but she can't go get counseling for that or rehabilitate herself in any way and see her kids again. Just done. So, lifetime, not even while they're just minors. Lifetime.
Right. And so our argument, now there were some provisions, loose provisions, that the kids would be going to counseling, and the court said, the counselor can decide when and if the kids should be starting a reunification process. There are opportunities to modify a protective order. In any instance where the protective order is longer than 2 years, the person against whom the protective order is issued is limited only to 2 opportunities to vacate it.
Wow.
So if and the first one has to be at least a year after it was issued, and the second one has to be a year after denial of the first. And then if you strike out on both of those, you're out of luck. You're never going to see your children again. So we were arguing that this is a violation of mom's constitutional rights because it acted as a de facto termination of her parental rights without the constitutional protections of a termination proceeding and without the constitutional protections of a criminal proceeding when it was based on the allegation of a felony.
Because the burden of proof would be higher in a criminal proceeding, right? You'd have to show a lot more evidence to get to that level.
Burden of proof is also higher in a termination proceeding. So in a civil protective order, our burden of proof is preponderance of the evidence. And so, lawyers in law school, when we're talking about preponderance of the evidence, they always make this little scale and they say it just tips one little tick one way and now you've met your burden. Very low burden of proof. And in a protective order, you're not entitled to a jury. So it's that judge, and did you convince them by 1% that this person should get a protective order longer than 2 years. Termination, the United States Supreme Court has routinely held you need a clear and convincing evidence standard to terminate someone's parental rights. So that was really the biggest piece of our argument, was that we didn't have a clear and convincing evidence standard, but we effectively terminated parental rights.
Yeah, it's like they did a little jog around, but with 14 to 20 days notice of getting ready for this hearing that could so hugely impact your life. I mean, you can hardly get in to see a lawyer and hire them in 14 to 20 days.
Right, and it's 14 to 20 days from the filing of the application, not from when the defendant got notice of it.
Oh, my word. So that is very interesting. Well, I can't wait to see what the Supreme Court does.
So we feel really good about our chances. Mm-hmm. In the Court of Appeals, the father didn't bother to file a response. And so we were really surprised to lose in the Court of Appeals. We had a 2-1 majority in dissent. And the majority said it was not a de facto termination because the mother retained, quote, some rights. And those rights are, the ability to confer with the dad. Well, the dad isn't conferring with the mom, so what good is that?
Yes.
The ability to talk to a doctor or talk to a teacher. Well, but if you go to that school, guess what? You're violating the protective order.
Oh, my word. So as an appellate lawyer, you're kind of grading our paper as trial lawyers, right?
Yes.
Because it's after the fact, it's all in the record, and you're looking back and saying, oh, okay, this is where they messed up, or this is what they should have done different. What tips do you have for any trial lawyers listening of mistakes you commonly see or things to look out for that you're seeing when you're grading the paper, so to speak?
Right. So if any new potential appeal comes to me or mandamus, the first thing I'm saying is I have to see the record first. I can't give you any opinion, whether it's the end client who's giving me their 2 cents on what happened, or even a lawyer who's telling me the judge got it way wrong. And until I look at that record, I can't know what your chances are for an appeal, because did you object when you should have objected? Did you put on your offer of proof? Did you, one of the biggest mistakes I see is lawyers giving up on objections, or sometimes judges saying, yeah, I get it, you're objecting to this. I'll give you a running objection or something like that. Don't just let the judge stop you from objecting in that way. Keep objecting over and over, because I don't think running objections are really a thing. And a lot of lawyers and judges seem to think that they are. Keep objecting. Don't just say, okay, the judge clearly does not want to hear me object anymore on the same issue that he's letting in and I don't think should be in. Keep objecting.
One way I handle that when I'm in trial is if I can tell the judge is getting aggravated, but I'm worrying about my record, I just explain that to the court. And I say, Judge, I heard you, and I'm not trying to be disrespectful of the court, but I have to preserve my record, and I know you understand. And then maybe the judge, will at least understand and maybe respect I'm trying to do the best job for my client.
And by doing that, you're also putting it in the record that you're trying to do this. And to the extent the judge shuts you down, it's clear that you have tried and you got shut down, and not that you weren't trying to make the right objections.
Oh, good. I didn't even know. I got extra credit for that.
Yeah, and with offers of proof, I've the Story case, that was one of our issues, was that the judge didn't allow an offer of proof on evidence that the dad was abusive.
Oh.
And the trial court just said it's not relevant because we're here to talk about if mom's abusive. And our position was it's absolutely relevant because it goes to the credibility of the witnesses. And if we're relying 100% on dad's testimony or 99% on dad's testimony, then maybe we should hear all there is to hear about dad. The Court of Appeals in that case said it was harmless error, which I disagree with completely, because how do you know if you don't know what's in the offer of proof?
Right.
But, we also run into trouble with time limits. And, I've seen judges let you put on an offer of proof after it's over, so that, the court reporter sticks around and you make your offer of proof, but the judge is gone. Don't forget, if the judge said during your trial, I'll let you make an offer of proof at the end.
You have to make sure
you actually do it. Yeah.
That's where it's helpful. If you can't afford to have an appellate lawyer there, at least have a paralegal there who makes notes of that kind of thing. I always have a check sheet with all the exhibits I'm expecting to try to put in, and then did they come in or not? Admitted, denied, to just have somebody double checking that I did offer it and the judge did rule on it coming in.
Right, because if it doesn't get ruled on, it's not in. And so if your objection doesn't get ruled on, it's overruled.
And it's not a problem to circle back later. Like if you realize later in the trial, the judge never ruled on Exhibit 3, it's fine later to say, Judge, I offer Exhibit 3, and the judge will still rule then. It's not like if you missed it at the time that it was logical to do it. You can circle back.
Right. And time limits, I think, also are one of the big issues that I think need to start being appealed. I know there's some courts, rumor has it, there's a court out there who, in a final modification trial, you get 30 minutes aside. And I really would like to see somebody appeal that. Now, the problem is, if you're not putting on some sort of offer of proof about all the evidence that you would have put on,
Had you been
had
given
it
more
been
time.
more, then you're going to lose. You've waived your right to complain about, or it's harmless error. Because you have to prove that it hurt your case to only be
Right.
given 30 minutes per side.
Right. And do you want to spend part of your 30 minutes putting on your offer of proof if, as we've said, the most important goal is to win at the trial level?
Right. I think in that scenario, you need to try and get the offer of proof outside of the 30 minutes and object to it being included. So then now it's even more obvious that I'm objecting to the time limits. I'm objecting to the fact that you're making me do my offer of proof of the other 3 hours of testimony within this 30 minutes on top of whatever else I'm putting on. I know a lot of attorneys there'll be a pretrial or some sort of motion or discussion that's not on the record about the time limits. And they may be filing a motion to get more time and the judge denies it, and it's not part of that trial record.
You have to do it again.
Be sure you raise that objection again. Even if the judge already overruled you and you know it's going to make them mad, if you really think you need more time, make sure it is very clear from your trial record.
Absolutely. So let's say that my client decided we're appealing and we go hire appellate counsel. How long does it take typically?
An appeal is a painfully slow process. Most of the time, you're going to need to file a request for findings of fact and conclusions of law, and that's extending your deadline to even file a notice of appeal. So 90 days after an order is signed. An order is usually not signed till 30 to 60 days after your trial. It could be even longer depending on the court and the issues. So I usually tell people it's 12 to 18 months from when you file the notice of appeal. But it could be 4 to 6 months from your trial, maybe longer, before you even get to the point of filing a notice of appeal.
So we're talking a couple of years.
Right. And a lot of times, like custody cases, mom versus dad, standard, generic custody case, most of those are not going to be a good case to appeal, no matter how wrong the judge got it, because it takes so long.
And life has gone on and the kids have grown.
Right. And if the judge got it so wrong and it's horrible for the kids, then in a year you go back and modify that and you get it changed before you ever even would get a ruling on the appeal.
And how much would it cost typically? And I know it may depend on how many issues and the complexity, but is there a ballpark of, hey, can I appeal for $5,000 or?
Definitely you cannot appeal for $5,000. It depends on a lot of things. The length of the trial is really important, because if you had that 30 minutes aside trial, it's going to cost way less to appeal it than the 1 week long or 2 week long jury trial. So that's a big piece of it, because especially if your appellate lawyer was not your trial lawyer, they are going to have to dive in deep on that record to see what happened and what the issues are. So, I mean, we are normally a $15,000 retainer for an appeal, a relatively simple or low issue appeal, particularly if it is something that we do a lot of, like parent versus non-parent appeals, we do a lot. So we have all the briefing, we just need to update it and base it on those facts. You know, those usually can be done at that amount. But if you're having, one of my law partners just had an appeal that had 80 volumes of the reporter's record.
Wow.
And when you have something like that, I mean, it's just digging through it takes hours and hours and hours and hours. So, you know, the sky's the limit when we're talking about a trial like that.
So it really has to be an amazingly important issue, because it's going to take forever and it's going to be expensive. One area in the property law area of family law that I see appealed a lot is separate property versus community property. If the judge ruled something as community property and the lawyers feel like that was obviously separate property, then if the asset is big enough, that could make sense.
Right. Property issues are usually much more ripe for appeal than kid issues because kid issues can be modified and the property issues can't. So this is your only chance to try to go get that property issue overturned. So you look at what's the value of the property in dispute and is it worth the cost of appealing it? So if you're talking about a $10,000 account,
Not
it's not
worth it.
worth it.
Yeah.
But if you're talking about a $100,000 account, it might be.
Yeah, or land that's
Right.
expensive or something where, okay, that might be worth the effort. If once they consult with someone like you say, hey, this has a decent chance.
Right. And oftentimes, because those are happening in divorces, which many also have kid issues. So usually it's, all right, there is a property issue here that is worth appealing. Are there any kid issues that we should go ahead and throw onto the staff?
While we're doing it.
Right. If there are kid issues, we can throw them in, but the kid issues on their own are often not worth the appeal.
So they have to think about it. In the child piece, or in the property piece, what happens in the meantime? So let's say the trial court ruled and we appealed. Are we doing what the trial court said in the meantime?
So the judgment stands unless you get a temporary order pending appeal that says it does not or that changes it in some way. On kid issues, most of the time, it's not worth it because you know who's going to hear that temporary order pending appeal?
The same judge.
Same judge who just ruled against you. So the odds of them changing it in a 20-minute or 30-minute assigned temporary orders hearing after they heard a full day or longer trial, pretty slim. There are property issues that are often worth filing a motion for temporary orders pending appeal because you want to preserve the estate.
Yeah, don't go sell the land we're fighting over.
Right, exactly. So you can get a stay, essentially a stay of the execution of the judgment to preserve the status quo. The person wanting to do that is typically going to have to provide a bond security to make it happen. But I think your chances of getting a temporary order pending appeal are significantly higher on property than they are on kid stuff.
Would the bond be expensive?
I think it's going to depend on the value of the property that you are trying to hold up.
Yeah, because one way to look at it is if I just won at the trial court, I feel like I should do whatever I want with my property.
Right. Now, as the lawyer, if the other side has filed an appeal, I'm always going to tell my client, just hold.
Hang
Don't-
tight.
Don't go spending all the money or selling the assets. Let's just hold and see what happens. But if you're on the side trying to protect it, you definitely like a court order if you can get it.
Do people ever try to settle the case? Like once there's been an appeal filed, does that ever inspire people, hey, we don't all want to go through a 2-year expensive ordeal. Let's go to mediation and see if maybe there's ground. Can we settle at that level?
Yes, and that happens a lot. It sometimes is used as a tactic to try to get a settlement that's better than the trial court gave you. And sometimes, you got this piece on the kid side and they got this big piece on the property side and you're like, throw them a bone. Or it could be property and property or kid and kid. I'm going to throw them a bone on something they really want. Or they're going to settle just to avoid, they can't afford an appeal or they don't want to mess with it. That definitely happens. And certain courts of appeals will order you to mediate.
Oh, so you could be forced to go again. Even if everybody says, no way, we're never settling, we're going
Right.
to
And
the
there's
mattresses.
a docketing statement where they ask, have you mediated before? And should this case be ordered to mediation again? I haven't seen a court of appeals order you to mediation when you said it shouldn't go to mediation again, but that's not to say that it couldn't happen.
And would that be the same type of mediator you would have when you're dealing at the trial court level, or would it be a different specialist?
Definitely can be the same. The issues are the same. Now you just have this extra piece of what the trial court did.
Absolutely. Okay, so let's go back to your Supreme Court case. One thing that was interesting is you shared with me that you had somebody sharing some of your time in front of the Supreme Court. Tell us about that.
Yes. So when you have cases in the Supreme Court, Texas Supreme Court or United States Supreme Court, oftentimes big cases that are really interesting to a lot of different groups might have amicus briefs filed. So in our case, there were a couple of amicus briefs filed on our side. There was one amicus brief filed on the other side, and they usually have their own particular angle for why they're interested in your case. So one of our amicus briefs, I kind of had a relationship with this group from my last case because they filed an amicus brief in CJC. And so they did a brief here, and when we found out we got oral argument, former Texas Supreme Court Justice Eva Guzman had been involved in writing their brief. So they asked if I would share time with her. So normally each side gets 20 minutes, but I said, absolutely, I'd love to do that, and gave her 5 minutes of my time. So we prepped together, and I did the first 10 minutes of oral argument, and then she got up and did 5, and then I did the last 5 for rebuttal.
Well, that was probably an extra special experience.
It was.
She's really popular.
Yeah, it was. I learned so much, and it was just really fun part of why I love appeals is they're intellectual, nerdy, legal fun to me. And I love diving in on those issues and where are we going to struggle and how are we going to answer these questions that are going to be really hard to answer.
Was she helpful in that, of knowing what the court might ask since she used to be on the court?
Absolutely. And in knowing, like, don't focus on this, they're not going to like that. Or, I think this issue over here is really going to be important to them. How are we going to handle that?
It's interesting that these groups are interested and want to do this briefing. It's almost like they're lobbying the Supreme Court.
Exactly. Yes, they absolutely are, because they see how is this case going to hurt the people that my group supports.
And is it a nonprofit usually?
Yes. So on our side, we had, I might mess up their name. That's the Family Freedom Project, and they are connected with the Texas Homeschool Coalition, which is who was our amicus in CJC. And it's, well, hey, there's no homeschooling here. Why do they care? Well, they care about protecting parental rights because they want, if we protect parental rights, that lets you homeschool. They also, looking back to CJC, we had, groups from all over the country that filed into that one where we're trying to protect the rights of parents to make medical decisions, or we're trying to protect the rights of parents to do some niche that had nothing to do with our case, but they knew that our overarching issue would impact their issue. So here we had 2 different parental rights organizations that filed in. The other side had a domestic violence nonprofit that filed, advocacy group that filed in. Anyone can file an amicus brief. And so like at CJC, we had this super random guy who filed one, and it was wild. So, but generally they are reputable groups.
Known nonprofits.
Right now, attorneys sometimes will file an amicus brief just on their own because they're an expert in that topic, or they, have done a lot of work in this area. But usually it's nonprofits.
And it's nice that people want the court to get it right, whatever right is, but obviously they don't all agree on what right is. And it's super interesting. So what area of Texas does your practice focus on?
So our litigation practice is DFW, North Texas area and surrounding counties. And then we do appeals statewide because it really doesn't matter what court it's coming out of. As long as Texas law applies, we can do the appeal.
Oh, that's exciting. Well, thank you so much for being here, Holly. This was very interesting.
Well, thank you for having me.
Absolutely. Thank you all for listening and watching the Melinda Eitzen Show today. And if you have any appellate needs, Holly Draper is excellent, as you can tell. She knows what she is doing, so consider her for your future needs. And hopefully we learned a little bit about when does even appeal make sense. Please tune in again next time.